Hello, everyone. This is Randy I am an employment lawyer practicing out of Toronto, Canada. With me today is a very special guest, Rick Schubert, who is a tax expert. And today we will be tackling a very important and very timely topic, which is how do you become a non-Canadian tax resident? How do you leave the country and stop paying taxes into Canada Revenue Agency? How do you stop paying Canadian taxes? And perhaps how do you pay lower taxes in a different jurisdiction? So Rick is going to be the expert on this, and we will pick his brain to see how that happens for ordinary Canadian citizens who are thinking of leaving the country. The reason this is really timely is because of the economic and political situation in Canada right now. I get asked, and many of my friends and colleagues in the professional field, we get asked this question quite often, which is, how do I leave the country? There's actually a lot of people who are thinking of leaving the country, given Canada's economic situation, and given that it's harder to buy property. A lot of people are not very satisfied with the political situation here. Taxes have gone up in recent years due to government policies and legislative change. So there's a lot of buzz around leaving the country and becoming a non-Canadian tax resident. Rick is here to answer your questions. So Rick, do you want to introduce yourself?
Hi, yes, Rick Schubert. I'm a lawyer. Have a background in employment law, and I morphed mid-career more into all aspects of taxation of employment. So that part and parcel of that included, when are you taxable in Canada, when are you not taxable in Canada on income, and what aspects of your income get taxed globally and what get taxed domestically. And that's what we're going to look at today. The CRA has a relatively well-articulated position. It's set out, for those of you who might be really keeners, set out in folio S5 F1 C1. That's a highly technical document, but does set out their policy well. Basically, if you are a tax resident of Canada, you're taxable on your global income. So anything you make anywhere in the world, you're a tax resident in Canada, you have to pay tax to the Canadian government. We can get into a little bit of discussion about tax treaties later on, where you get, if you're taxable in two different jurisdictions, you get credits in one jurisdiction as long as we have the right alignment in terms of our Canadian and other domicile, other country tax treaties, to avoid double taxation, but sometimes double taxation is not avoidable. If you are not a tax resident of Canada, you are taxable only on income earned in Canada. So, for example, if the only source of income you had from Canada was your CPP and you'd retired, excuse me, to some other jurisdiction, you're no longer a Canadian tax resident, you would still be subject to taxation on your CPP income. So there'd be withholdings on that income, excuse me. But the rest of your income earned anywhere in the world, not subject to Canadian taxes. And so Randy was referring to earlier, people looking to exit want to find themselves in the latter camp, where only income earned in Canada would be subject to Canadian tax, and the rest of their income, excuse me, would be subject to tax only in that lower tax or no tax jurisdiction that they moved to. I'll mention, because I've had a lot of clients who were either U.S. citizens or U.S. green card holders. I'll just make a quick reference to the U.S. situation, which is unique, as far as I'm aware, in the world. In the U.S., you're taxable on your worldwide income on the basis of citizenship or holding a U.S. green card. Doesn't matter where you're resident. These people, so if you go down to the States, you get a green card, Canadian citizen, you move back here, you still have your U.S. green card, you're still subject to U.S. taxes. A lot of people don't know that. So that poses a whole separate set of challenges, but also some opportunities, tax planning opportunities. So the courts look at, and the income tax looks at, are you ordinarily resident? Or are you a deemed resident? That's two types of residencies. Ordinarily resident, if you are ordinarily resident in Canada, that portion of the year during which you were resident in Canada is the portion of the year in respect of which your income will be taxable. So if you're if you were here for if you're ordinarily resident for 6 months, it would only be in respect of that 6 months income that you would be taxable in Canada. And that would be your global income, because again, we're talking about you being a tax resident in Canada. However, if you're a deemed resident, doesn't matter during what part of the year you became a deemed resident, you're taxable on your global income for the entire calendar year. Okay, so that's an important distinction. Are you ordinarily resident or deemed resident? You cannot be deemed resident if you're ordinarily resident. So the first test is to determine whether or not you're ordinarily resident. If you're ordinarily resident, sometimes that's called factually resident, then you can't be deemed resident. So you're in no danger of being taxed on your global income for the entire year. That's only if you're not ordinarily or factually resident that you could possibly be a deemed resident. We'll get to looking at how you become a deemed resident later on. You may also be a deemed non-resident. So a little complicated. Irrespective of whether you are factually like an ordinarily resident or a deemed resident under subsection 250 sub 1 of the Act, you could be deemed by virtue of the tiebreaker rules in an income tax treaty that Canada has with another jurisdiction to be a non-resident. So, and we will look at that again later too. As you can see, this is not a simple thing, and it does require getting some good tax planning advice before attempting to execute this type of a move. An individual will be deemed to be a non-resident at a particular time if at that time, although otherwise factual or deemed resident in Canada, the individual is considered to be resident in another country under the tax treaty between Canada and that other country. So I'll talk about the tiebreaker rules in not very much detail because this doesn't come up a whole lot toward the end of the discussion.
So Rick, just stopping you there, can you give me an example, and you can give me a hypothetical example. What is an ordinary resident and what is a deemed resident, if you could create?
Okay. An ordinary resident would be somebody who, for example, has a dwelling in Canada, has a significant residential ties to Canada, has bank accounts here, member of clubs here. You might be employed here. You're living here. The text, there's a Rand quote where basically, in the ordinary course of somebody's life, where would you say that they're living, and where would you say that are there any other jurisdictions that have the same type of ties? So ordinarily resident is just somebody who has either the primary factors of residency, which would mean your house is here, your dependents are here, your spouse is here, or your common law partner is here, right? Your kids are in school here, those types of factors. A deemed resident is when somebody is sojourning. The primary one we're concerned about is when somebody is sojourning in Canada. And that means they're basically coming to Canada, whether it's on business or vacation or whatever, and establishing a temporary dwelling here for more than 183 days, or for 183 days or more per year.
Okay. So let's focus on ordinary residents first, because I think the majority of our viewers who are interested in this topic are most likely ordinary residents, and they're not here on business or on temporary assignments. They're interested in leaving the country or somehow becoming a non-Canadian tax resident. So if you're an ordinary resident, let's choose the most common example: someone who has a job here, who has property, has a house, has ties in Canada for a number of years, say 10 plus years. Maybe they even grew up here, and they're interested in becoming a non-Canadian tax resident, perhaps because they have a business elsewhere, or they're thinking of switching jurisdictions for lifestyle purposes. What would that person need to do to become a non-Canadian tax resident?
Okay, so leaving Canada. The most important factors are residential ties. Generally, unless an individual severs all significant residential ties with Canada upon leaving Canada, the individual will continue to be a factual tax resident of Canada. Significant residential ties: dwelling place, spouse or common law partner, dependents. Okay, those are the three paramount ones. The dwelling, where an individual who leaves Canada keeps a dwelling place, and it doesn't matter if it's owned or leased, available to his or her occupation, it will be considered to be a significant residential tie. Now, if I own a home in Canada, and I don't want to get tagged with that particular factor, I could lease it out to a third party on arm's length terms and conditions, and the CRA will consider all circumstances of the situation. So if it looks like that's clean, that's arm's length, leasing it out, and they will look at other factors. For example, it might just be a bad time in the market to sell my house, right? I'm in a trough. I don't want to sell now. The CRA will take that into consideration and say, well, okay, it makes sense that you would just lease this out, because they're trying to divine what your real intentions are. Are your intentions to actually, permanently leave Canada, or are you just adopting this position as a tax dodge, to put it bluntly? So you can lease that out, and if it's, as I say, if it's to a third party, arm's length terms and conditions, that'll essentially remove that from the map in terms of significant conditions. Your spouse might stay behind until the kids finish their school year, right? That would be considered okay. Whereas if your spouse just stays behind permanently and the two of you have not split, I mean, it's one thing if your marriage has collapsed, that's okay, that's fine. But if you're married and the marriage is not collapsed, the fact that your spouse is staying behind, your dependents are staying behind, would be a significant considered a significant residential tie. Okay. So that goes against finding, not necessarily determinative, but it's a significant finding of a factor against concluding that you have given up your Canadian tax residence. Then there are secondary residential ties. Want to have a look at those?
Sure. So just to summarize for our audience here, we have the primary ones, which is your dwelling place, your dependents. So those are the primary, and Rick, why don't you explain the secondary?
Yeah, exactly. So the secondary ones, we've got a fair list of them here. They look at, do you have personal property in Canada? Have you left, for example, have you put all your furniture, your clothing, automobiles, recreational vehicles in storage? Right? Looks like you're coming back. Or have you gotten rid of them or brought them with you? Social ties. in Canada, memberships in Canadian recreational and religious organizations, economic ties with Canada, such as employment with a Canadian employer and an active involvement in a Canadian business and Canadian bank accounts. Retirement savings plans, credit cards, securities accounts, landed immigrant status or appropriate work permits in Canada, hospitalization, medical coverage from a province or territory in Canada. A lot of times people don't want to give up that Canadian medical coverage, right? And you know, that's something you might have to make a hard choice on. They even look at, you know, are you maintaining your driver's license? Vehicles registered in a province, seasonal dwelling in Canada or lease dwelling, Canadian passport, memberships in Canadian unions or professional organizations. So quite an extensive list. And those are considered the secondary residential ties. So not as important, obviously, as the significant residential ties. But this is a question of fact in each instance, as they like to say. So they look at it on an omnibus basis, look at all of it. Then there are other residential ties that are, these are almost de minimis, but they actually do get looked at in court cases sometimes. Post office boxes, safety deposit boxes, personal stationery, including business cards that have a Canadian address on them, telephone listings, magazine subscriptions. those things have all actually been looked at. So there's quite a few things to look at in terms of getting a squeaky clean exit.
Okay.
Right. Yeah.
So suppose we have this hypothetical person who's an ordinary resident, you know, has a dwelling, has a spouse, dependents, but is thinking of leaving the country. And suppose this person has a job in Canada, and as I already said, has property. What happens to this person if they choose to leave? What happens to the property and these ties? How does that person get rid of these ties, and what are the implications?
Yeah. Well, there's if you do, one of the things that CRA looks at is, have you complied in terms of determining your intentions to leave and change your tax residency? Have you complied with the deemed disposition rules, right? There's a deemed disposition of capital property if you change your tax residency, if you exit Canada and give up your Canadian tax residency. So CRA will look at, okay, well, did you do what you're supposed to do? And that is either pay the tax on the capital gains, which were deemed to have been realized, or post acceptable security. You don't actually have to pay the tax. You could post security for the tax. It's cleaner if you just pay it, but and you do get an adjusted cost base in case you do come back, right? So if I paid, let's say that I bought a cottage and for 100,000, and it's now worth 200,000, and I pay. So I've got a capital gain of 100,000, taxable capital gain of 50,000. I pay the tax on that. I now have an adjusted cost base of 200,000. So if I sell the property sometime down the road, right, my tax is calculated as though my cost base is 200,000 instead of 100 now, right? So, but
just stop me there. If you could just explain to our audience, what is a deemed disposition?
Oh, deemed disposition is where you haven't actually sold the property, but for tax purposes, they're saying we're going to treat you as though you did sell it, and we're going to charge you capital gains taxes as though you sold it. So if you're sitting there and you have shares outside of registered plans, there are certain properties that are exempt. So if you're holding properties in like a registered pension plan, an RSP, this type of thing, those are exempt from the deemed dispositions. But anything you're holding outside of that. So if you're holding shares personally, you own a very common thing is a cottage, right? You know, principal residence, a deemed disposition on that is a non-tax event because it's tax exempt. Right? So the fact that you're deemed to dispose of your principal residence is neither here nor there for tax purposes. But any other types of capital property like that, say the most common ones being cottages and stocks, you're deemed to have sold and realized a capital gain, or you may have a capital loss on it too.
Sure. So I'm going to walk this through for our audience here, and you fill in the details. Suppose we have this hypothetical person who owns a house. Let's suppose that's the primary residence. They own a house in Canada. They have an RSP in Canada with certain securities and stocks. They own, say, a margin account outside of the RSP, just a stock trading account that's not in an RSP and not in a TFSA. It's just a normal trading account. They have that. Let's suppose in this scenario, we make it a little bit more complicated. They have a cottage that they use personally, and let's suppose they have a rental property. Let's suppose they have a condo that they rent out.
Okay.
And let's say that they have a car, and they have employment here in Canada. So in this situation, and correct me if I'm wrong. So the deemed disposition on any of the capital gains. So the person, the primary residence doesn't matter because there's a primary residence, principal residence exemption anyways. So that doesn't matter. The items within the RSP, that's protected?
Yeah.
Okay. So even if the person leaves the country, becomes a non-Canadian tax resident, they can still go back and withdraw the amounts in the RSP at some future date?
Yeah, and those will be subject when you start withdrawing from RSPs or DCRPPs, defined contribution registered pension plans, or defined benefit registered pension plan, or retirement compensation arrangement, any type of retirement registered plan like that. When you start drawing income from it, it's subject to withholding in Canada, and the rate of withholding that it's subject to depends on the tax treaty. But to use the most common one, I ran into the U.S.-Canada one. If it's withdrawn in periodic payments, and there's a specific definition for that. If it's withdrawn in periodic payments, the withholding is 15%. If it's withdrawn as a lump sum, it's 25%.
So you're taxed on it, but not as per the usual marginal tax rates. You're taxed on it differently based on these flat rates. Right,
and you don't get taxed until you start pulling the income out of those registered vehicles. So in section I think it's 118. There's a specific list of capital properties that are exempt from the disposition.
Okay. So this hypothetical person has left for jurisdiction X. So we talked about primary residence. The RSP they can keep there. There's no deemed disposition. They can get it back. They can take the amount out at a later date and be subject to flat tax rates. The cottage, presumably, if there's appreciation on the cottage, then they'll have to pay taxes on the cottage. But does that mean they're in effect selling the cottage? Or do they have to sell the cottage?
No, they don't have to sell the cottage, but they're deemed to have sold the cottage.
Okay.
Right. So, for tax purposes.
So that's interesting. So the person goes to jurisdiction X. They're deemed to have sold the cottage. What then happens to the cottage? It just sits there if they have no intention of actually selling it?
Well, yes. And now that would be considered to be a form of residential tie to Canada, right? So that's when you're looking at your scales, has the person actually changed their tax residence or not? That would be a factor that would tilt toward they haven't changed it, right? That to the extent that the more things you leave in Canada, the bigger the chance there is that the CRA is going to say no, you haven't changed your tax residency.
Okay.
So I mean, so you can leave it, right? But you have to look at the whole. If you're squeaky clean on everything else, that's probably safe, But if you've got some other factors residential ties and secondary ties, now you're in danger of tilting it away from having been found to have changed your tax residency.
I see. Okay. So there's a deemed disposition in that you'll have to pay the tax as if you sold the property. You
Correct.
don't, I'm talking the property here as the cottage in this hypothetical example, but you don't actually have to sell the cottage. But if you don't, that could be one of the factors the CRA will consider as to whether you can be a non-Canadian tax resident.
Precisely.
Okay.
Yeah.
So that's with the cottage. Let's look at this rental property the person has. Would there be a deemed disposition on this rental property?
Yes. That's a capital property, and it's held, it's outside of the excluded items. Yeah. So
what if the rental property is, for example, owned by a corporation, or if there's a small business that the person's running at the same time?
If it's owned by a business, you're deemed to have and that you own the corporation.
Yeah, suppose the person,
yeah.
I'm just making it more complicated here, but just so our viewers can understand all the implications. Suppose this person is employed. Because that was the scenario we gave. Because that's going to be important. I'm using that so that we can talk about employment. The person's employed, but suppose they run a little side business, right? They're the sole shareholder of a small business. Let's suppose there's a little bit of active income coming in. They're maybe selling something online on the side, for example. And then in this scenario, just so we can get the answer from you, they run a rental property. The rental property is owned by the small business, and they say Airbnb this property for argument's sake. What would be your thoughts on this scenario?
You would be deemed to have sold the shares in the company that holds those items.
Okay, so you would have been deemed to sell not the property, but the shares of the business.
Corporation that owns those properties, yeah.
Okay, then how do you evaluate, because this is not a public company?
Well, then you'd have to engage some high-priced business valuator. You have to engage a business valuator. And the CRA has a well-articulated position in terms of, the various means of valuations that they will find to be acceptable, multiple of EBITDA, breakup value, blah, blah, blah. There's probably 4 or 5 different methodologies that could be used. But yeah, if you want to conduct this and not get pushback from the CRA, you hire an experienced arm's length third party professional business valuator to conduct a business valuation on it.
Okay.
And that's your basis for your capital gains calculation.
I see. Okay, so I'm going to go back to that topic in a second, because I think that's a really interesting topic. But just going with the other hypotheticals in this scenario, the person's employed here in Canada. Presumably, they would have to cease their employment in order to be a non-Canadian tax resident, or can they work remotely from a Canadian employer?
You're getting it, then that gets you into visa issues too, which we won't touch on. But in terms of where you're entitled to do certain work from. But assuming you're moving, you're going to have working visas wherever you're going to, and you can do the work remotely. That if you're coming back up here, for business meetings, it begs a question of the sourcing. And what sourcing means is, okay, where am I actually, what is the source of that income? Where am I actually earning that income from? If I'm actually earning that income from efforts that I'm putting in a Canadian business, then I'm going to be paying Canadian tax on that income anyway, despite the fact that I've moved, because it's considered to be earned in Canada. Don't forget, even if I'm no longer a tax resident of Canada, I'm still tax is still exigibile on any income I earn in Canada, right? So if I'm employed by a Canadian company, and the CRA, for whatever reason, takes the view that I'm actually earning that money in Canada, then I will be taxed on that income in Canada.
Okay, as per the normal rules of taxation.
Yeah. Mhm. Yeah.
Right. So
Yeah.
so the company will provide a T4 to the employee,
Yeah.
and deductions will be made at source.
Yeah. And since the great COVID migration and so many people working remotely, I mean, the CRA has come out with a new set of rules to determine what province you're actually working out of,
Okay.
right? But honestly, Randy, I haven't looked at whether they've got new rules to determine what country you're working out of. You've actually moved out of Canada. I've just been looking for clients, and okay, the person, the headquarters is Toronto, but the person is working from Hull, Quebec. What province am I taxable in? That's all I've looked at so far.
All right. So that's a live question, perhaps for one of our future videos, is to figure out. So we'll put a flag in there.
Yep.
If you're working for a Toronto company, but now
Remotely.
you're living in jurisdiction X, it's not Canadian jurisdiction, are you taxed by the laws of jurisdiction X?
Yeah. What factors would the CRA look at to determine the source of that income? Yeah.
So, well, we can research that. So that's a very interesting topic, and I think it would apply to a lot of people.
And I should mention too, because of the type of people who would be looking at this, Randy, where you've got equity-based comp, stock options, share appreciation rights, this type of thing. There are elaborate sourcing rules that look at, okay, when was the grant? When was the vesting? And do we need to prorate the income? So if I get a grant of stock options tomorrow, and it vests 1/3, 1/3, 1/3 over 3 years, and I move to the US, move my tax residency to the US in the middle of that, what part of that income is considered Canadian source and what is considered US source because I've already moved, right? So there are fairly well-defined sourcing rules for deferred income that we could look at some point in the future as well.
We'll just finish off with our hypothetical person here. The person has a car, right? So if there's a disposition, the reason I use the car, because cars usually depreciate.
You're going to lose money on it. Yeah.
So you get a tax rebate, or what happens there?
No, because that's personal. It's personal property. So you don't get to claim a loss on it. Although you would get taxed if you had a gain. It's a little unfair.
Okay, so almost impossible for a car, but
well, yeah, I mean, if you had a Ferrari F50 or something, some really you're a car collector, then you might be in a different ballgame where you would be seen to be an investor, and that would actually be capital property. But most people's cars, no, it's just personal property, right?
Okay, so that's just one of the secondary factors as to whether you're a resident that goes into.
Yes, if you keep your car in a garage here, then it's like, well, okay, did you really intend to leave? Yeah.
Let's go back to this business idea. I'm going to change the scenario a bit. So we have the same person, but instead this person is not employed. This person is a business owner, and we'll keep it fairly simple. The person is a sole proprietor, but has a corporation, say a numbered Ontario corporation, 1, 2, 3, 4, 5, 6 Ontario Inc. They run an active business in. Let's suppose they have income over the world. Let's suppose it's some type of online business where they sell some type of digital product, and there's income coming in worldwide, but the company is an Ontario corporation. So for someone like this who wants to move to, say, a lower tax jurisdiction, what would be the mechanism there?
They actually have different rules for moving a corporation. You can change a corporation's tax residency. And all I looked at in preparing for today was from the individual's perspective, but they're fairly elaborate sets of rules for changing the tax residency of a corporation. That is doable. And that for a long time was a big part of any international corporate tax practitioners' practice was finding, moving them to Iceland or or moving them to the Channel Islands or right to these lower tax jurisdictions. And then there's all kinds of additional rules about pricing. You know, you can't, these rules attempt to set it up such that you can't push all the profit to the no or low tax jurisdiction, right? The Canadian entity that's trading here still has to retain a reasonable amount of profit. At least that's what the rules try to squeeze out of you. They say, well, you know, you can't have all the profit in for these golf carts manufacturing that being occurring in Iceland, right?
For sure.
So yeah, so that's a whole different regime.
Now, what we talked about previously, where you're deemed to have sold the shares of the company, is that a little bit of a different scenario? That the person owns a small corporation, but you said previously in our call, the person is deemed to have sold. The deemed disposition is.
Oh, yeah. Well, if the person is moving themselves, if they are moving to a different tax jurisdiction, then the deemed disposition rules come into play, and they would be deemed to have sold. Those shares would be seen as capital property, and they would be deemed to have sold those shares. Yeah.
Okay. Then what happens to this business? Suppose it's an active business, it's earning income, but they're deemed to have sold the shares, so they're paying an amount of tax. Are they still then allowed to run the business in Canada?
Oh yeah, yeah, absolutely, yeah. It hasn't actually. It's just this. It's strictly for the purposes of this tax fiction. That there's this deemed disposition, not for any other purposes at all. So nothing is affected in terms of how you run the business or how you can run the business.
Okay, but suppose the person runs the business, they pay the deemed disposition as per this tax fiction. They move away, they still run the business for 10 years, 20 years in Canada. Would they ever need to pay tax again? Or now they pay deemed disposition once and that's it. It's a one-off.
Well, it increases your tax base if your shares, if you move back to Canada, let's say, you know, which a lot of people end up doing because of for medical reasons when they finally retire. If you move back to Canada, then you will have reacquired the shares at the new adjusted cost base, which would be the fair market value when you come back in. If you stayed outside and you were deemed disposition of the shares, then you wouldn't be subject to further taxation in Canada unless you became a Canadian tax resident again. Yeah.
So Rick, what are some of the jurisdictions that perhaps you've researched in the past in terms of common places that Canadians move to, and what are some of the implications for these jurisdictions?
Ireland is kind of an interesting one. I haven't looked at it for a couple of years, but it was an interesting one in the sense that Ireland, when my clients moved over there, didn't tax them on it didn't tax offshore income. So, you know, you could have a retirement compensation arrangement with millions of dollars in it, for example. You pull the money out. Let's say you do it lump sum, so 25%. Instead of if you're an Ontario resident, you would have paid 53.5% on that. So you've saved 28.5%. You park it in the Channel Islands. It's offshore from Ireland. You're not taxed on any of the earnings on that you know, $10 million or whatever it was. So that was a pretty interesting one. I actually had a plan. You know, one client that did that years ago. The one I most commonly see is US.
Yeah.
See lots and lots of that. I see Americans moving back to the States, green card holders moving to the States, and people retiring to the States. And the interesting thing, and I think I referred to this in our last session, but because with trusts, retirement compensation arrangements are like pension plans for executives. They provide pensions for money that's above the registered plan limits, right? Registered plan limits only go so high. And so if you're earning a lot of money, they don't cover anywhere near a reasonable pension relative to your income. So people set up a retirement compensation arrangement. In Canada, money goes into a trust. I'm the beneficiary of the trust. I'm the executive. I don't get any tax on the contributions to the trust. There's a withholding, refundable tax that's paid on it to the government that gets refunded to the trust as the money comes back out to me. So I have deferral, the executive, I have deferral on that, all those contributions to any taxable inclusion until I actually receive the money. The company making the contributions gets an immediate deduction for the full amount of the contribution. So if it's going to, cost, $10 million to fund this benefit, they get to deduct $10 million. So it's good for the company and it's good for the executive that way. But here's the kicker. If I'm a US green card holder or an American citizen, right? I pay tax on my global income. I'm a Canadian tax resident, so I'm paying tax in Canada. I get no inclusion on these RCA contributions, but in the States, I get an inclusion. I get a immediate taxable inclusion on the contributions. So, in our examples, it was, $10 million. Now, as I'm working in Canada as an executive from the States or a green card holder, I'm paying way more tax in Canada than I would pay in the States. I don't know what the current rate was, but last time I was doing this tax planning, it was about 32% federally in the States. So, and in Ontario is, 53.5 or something, right? So let's say just, there's roughly 21% difference. I'm paying that much more tax in Canada than I am in the States. So I'm accruing tax credits. Which is like, it's as though I've paid that additional tax in the States, that additional tax I paid up here. So let's say for the sake of simplicity, that my tax credits at the end of 5 years of working up here amount to $10 million, right? That 20% has added up to $10 million of additional tax that I paid in Canada, that over and above what I paid in the States. So I've got tax credits. So when I pull that money down into the States, right, it's all tax free. It's tax paid. I don't pay any tax on it. So net effect is, instead of paying 53.5, I paid 25%, or I could take it out periodically and pay 15%. And if I move to a state like Texas, which has no state income tax, all I'm paying is the federal rate.
And this is the magic of these private pension plans that we talked about last time, right? Is that?
Yeah. So that's kind of because of their taxation on global income. The US, and we see this with professional athletes too. I used to do this with professional athletes moving back and forth across the border, or coaches. Some of the coaches make mind-boggling amounts of money. So that was kind of a unique situation. And then, you've got the usual ones where you've got some of the smaller islands, which basically have no income tax. Now, a lot of times people get a bit of a surprise. They move down to the Caymans, and you're not paying any income tax, but everything's twice as expensive. Because it's all brought in, right? And so it's like, oh, well, I guess I'm actually not really ahead. So you have to look at that.
Yeah, for sure. You have to also understand where you're living and the costs of living. So for those of you who are interested in private pension plans, Rick and I have a previous video about private pension plans and RCAs and different mechanisms to create these pension deferred payment mechanisms. And there's some interesting ways that intersects with becoming a non-Canadian tax resident, and how that money is paid to you, and how that's taxed. And there's some creative things that Rick can do for you there.
Yeah. This is, I need to mention this. There is a form, Form NR 74, determination of residency status. So, you can make an application with the CRA, whether you're coming into Canada or leaving Canada, to have a determination of your tax residency status, and say, okay, I've done all these things, you know, am I safe to go or not safe to go? What's your ruling? It's basically, it's like getting an advanced tax ruling.
Okay.
Yeah.
So is this different from, is this different from the form where you declare yourself as a non-Canadian tax resident? There's a form, I believe, where you declare yourself as not being a tax resident. Or are we talking about the same?
Yeah, and NR 73.
Okay. So,
Yeah.
so you submit this to the CRA, and
Yeah.
the CRA will make a determination based on the factors that you present to the CRA as to whether, and the primary and the secondary factors we talked about today, as to whether you are a Canadian tax resident or are not. How often can you submit this form? Is it you know?
Oh, I don't believe there are any limits on that.
Okay.
I think you could try, and if you don't succeed, you could rearrange your affairs and try again. Yeah.
Sure. And who responds to this form?
The CRA. So it's some officer in the CRA, and if you're not satisfied with their opinion, usually there's, you can escalate it. But they will give you an opinion on your tax residency.
Is that opinion
And
binding?
it's binding on the Crown, but that is predicated on the facts provided being completely accurate and transparent. So it's predicated on your facts being fulsome and completely accurate.
Okay, so suppose our hypothetical person submits this form to the CRA. The CRA says, we deem you not to be a Canadian tax resident. And does that mean this person the following year does not have to file income taxes? Like they don't have to file their normal filings by
Oh, if they don't have any income in Canada, they don't have to. That's right. But if they have a business here, and if they have I don't know, CPP or OAS or whatever, right? They might have to file.
Okay.
But that's only in respect of Canadian income. If they have no Canadian income, they don't have to. We should just very quickly touch on sojourning, because
Sure.
you can ruin your tax residency with sojourning and ending up with if somebody is this is probably going to be more relevant to say a U.S. person coming up frequently. If you're here more than 180 or more than 182 days, and a part day counts as a full day for their calculations, you can be deemed to be resident under 250 of the Act, and with the result that you're taxable on your global income for the entire year, as I mentioned. So that's could be a pretty horrific result. So one has to be very careful about that. If you are coming up to work, let's say that you're in New York and you're flying up for board meetings and then flying back the same day, for example, right? That wouldn't count as a day. That's not sojourning. So for sojourning to occur, you have to at least set up a temporary residence, even if that's for a very short period. So in other words, stay here overnight.
Okay.
If you're returning to your normal place of residence, as soon as the work is over, that's not considered sojourning. So anyway, that's what I just wanted to get that out.
That's important. So the 182-day limit, in that you can't be in Canada for more than 182 days. Is that correct?
180, yeah, 182 actually. 180 if you hit 183 and you've gone over the limit. Yeah.
Okay. How does the CRA keep track of this?
Well, it used to be that you just had to fill in something at the end of the year that said how many days you were here and not. Now I understand that everything is stored electronically. So you're using your passport, used to be you could use your driver's license to cross the border, right? Now it's all passports, all scanned, goes into the system. So I think you still, last time I had to do this, I still had to fill out manually when I was here and when I wasn't here and stuff. But they can check all that, right? They can verify it with their electronic records.
Okay, so they'll actually look at your exit and enter records from customs.
That's my understanding, yeah.
Okay.
Yeah,
So
I haven't seen them do that, but that's my understanding, yeah.
Okay, or at least they have the capability of doing so.
Yes, yeah.
If required.
Yeah.
So if they find that you didn't leave and you've been here for 200 days.
Yeah.
that could,
then you're sojourning, yeah.
okay, that could torpedo your non-Canadian tax resident status.
Yeah.
Okay, so is it common for people to become tax residents and non-tax residents to hop back and forth?
Yes, because a lot of times they're still conducting business back here.
Yeah.
Right. They're members of boards, right? They got to come up here quarterly for the various boards that they sit on. This type of thing. Although I am finding, Randy, that people for expense reasons and convenience reasons are using Zoom and Teams and this type of thing a lot more than they used to.
Okay.
Yeah.
Now we're getting close to
less travel than it used to be.
Yeah, for sure. We're getting close to the hour, so I'm just going to ask you 1 or 2 more questions, and then I'm going to give you the opportunity to give out your contact information to viewers who may want to contact you for tax advice. But the form that you fill out where you get the opinion from the CRA, and I'm just talking about timing here. Does that happen first before the deemed disposition, or what happens first technically? When do you have to pay deemed disposition tax?
If I were doing it, if I wanted to change my residency, I would do the deemed disposition. I would post security rather than pay the tax.
Okay.
First, because I would want the CRA to look at this and go, oh, okay, he's treating this as though he's changed his tax residence, right? He's checking all the boxes, because that's, as you recall, that's one of the boxes that they look at. That's one of the factors that they look at is, have you complied with the act as though you were changing your tax residence, right? So
how do you do that? Like mechanically, how do you post security?
Well, since all my clients have done is actually pay the taxes, I'm not sure what the mechanics are. That's an easy thing to look up.
Okay. All right.
Yeah.
So you could, in theory, post.
You're gonna have to send the money to the federal government, right? Or they will hold it in some kind of an account, for you.
Okay. So the money will leave your bank account in this case.
Yes. Yeah.
And be held in trust.
That's my understanding now.
Or in escrow or something, whatever the legal term may be in the situation. Okay, and then you would.
But basically, it ties it up so you can't use it.
Okay, so it's been tied up, and then you submit the form for the tax opinion now that security has been posted.
Yeah.
And if the CRA now deems that you are no longer a Canadian tax resident, then they would just deposit the money that you've given to them. Is that what happens?
Well, if you're just posting security, like the fact that you're thinking you might come back to Canada eventually isn't fatal to an application, right? A lot of people do come back, but they're away on a sufficiently permanent basis to change their tax residency. So if you came back, you could be. I guess the trigger event would be when you re-entered, you would be reacquiring these properties, and then it would get sorted out at that point.
Okay. Interesting.
Yeah, because you'd be reacquiring them at a higher tax basis.
Yeah.
This type of thing.
So yeah, that's an interesting complication.
Yeah.
Rick, do you want to tell our audience anything else about this situation? Any important factors we may have missed?
Well, it's just it's very. I was going to say it's very fact specific, in particularly in the sense that you really need, when you're planning this, you really need to have somebody look at the Canadian tax treaty or tax convention with whatever jurisdiction you're planning to move to, right? To see what how the tiebreakers work, to see what the residency requirements are on the other end. It's a fairly complicated undertaking, and with the deemed disposition, you can end up tying up a fair bit of money depending on how your assets are allocated. So this is a pretty big planning thing. This is not something that you do impulsively or lightly.
Okay.
I would just throw out that caution.
Sure.
Yeah.
Rick, why does the jurisdiction that you're going to matter if you're going to become a non-Canadian tax resident?
Well, because you can end up being tax resident of, you can be a dual tax resident. You can be tax resident of two places. And if you want to make sure that you're going to be, when the tiebreaker rules are applied, each tax treaty or tax convention has its own tiebreaker rules.
What's a tiebreaker rule?
The tiebreaker rule is where the facts dictate that I'm actually tax resident of two different jurisdictions. Okay, how do we break that tie?
Okay.
Right. So you want to look at, okay, I want to make sure I've ticked all the boxes on the other end to make sure that I win that tiebreaker, that it's going to go in favor of the jurisdiction, low tax jurisdiction I want to be in, rather than it's going to come out in Canada's favor. Right?
I see. So that could be the reverse, which is owning property there, having your spouse there, dependents there,
Yes. Yes, exactly. You have another family there.
Yes, your second family is in Panama. That's like, look, I have my second family.
Yeah.
I have kids there. The first family doesn't know about it, but I did it.
Exactly. One time I was, when I was involved in pension law, we were one of our clients was a big municipal pension fund, and when the member died, 3 spouses came to claim the death benefit. None of whom knew about the other ones.
Mhm.
It was 3. The 2,
Exciting situation.
but it was unbelievable. It was 3. None of them knew about each other.
Oh,
No.
wow. Okay.
He traveled a lot.
Okay. Very exciting life, it appears.
Yeah.
Perfect. Rick, any final comments?
No, people want to get a hold of me. They could just call me at 647-299-3357. And yeah, Richard.C.Schubert with C, SCHUBERT @gmail.com. Yeah, that would be it.
Okay. Well, if you need tax advice, especially with respect to these very complicated planning situations, Rick Schubert is your man. I hope you've enjoyed our interview today. In the future, we may do another one of these on a different topic. Rick's given out his contact information. Feel free to reach out to him if you wish to retain him as your advisor going forward on the tax matter. And until next time, thank you very much for joining us, and I hope you have a wonderful day.
Okay, great. Thank you. Bye now.
Bye-bye.